Well, thank you very much, Baljinder. This is Andrew. I'm going to welcome everyone and introduce our presentation this morning. I will say, first of all, I hope everyone had a good, relaxing, long weekend. We're back at it pretty early this morning, so we'll try to keep the energy up. My name's Andrew Robb, as you heard. I use he and him pronouns. I am coming to you from my home in Vancouver in the traditional ancestral and unceded territories of the Musqueam, Tsleil-Waututh, and Squamish peoples. I want to start, I will give Alison a chance to introduce herself as well, but I want to start by acknowledging, I want to thank my colleague Leon Thompson for designing the PowerPoint slides we're going to be seeing today, because I am terrible at that sort of thing. And I'll say a bit more about that in a second. Alison, should I give you a chance to say hello first?
Thanks, Andrew. Sure. Good morning, everybody, and welcome to this year's Welfare Law Update. When we had live versions of the Provincial Advocacy Training Conference, this is often the session that kicks off the conference, so I know that we're already a week in. But basically just an overview of the session is that we're only going to be talking about updates, which means changes since we had conference last October. And we'll be doing a quick overview of those. And then hopefully, if we have time permitting, some fact patterns. And Andrew's going to start the presentation. And he'll be starting with a beautiful land acknowledgement. The slides today are certainly nothing I could ever have prepared. And I'm also in Vancouver today, so similarly to Andrew, on the unceded ancestral territories of the Musqueam, Squamish, and Tsleil-Waututh peoples.
Thank you, Alison. Can we go please to the next slide? Right, so as you're going to see, the slides that my colleague Leon created for today's presentation are using a theme of Northwest Coast art created by an artist named Bill Reed. And as it says here, Bill Reed, who lived from 1920 to 1998, was a pivotal force in Northwest Coast art who empowered and inspired a generation of artists. And as I said, all the background art you're going to see was created by Bill Reed. My understanding is Bill Reed's art is inspired by his Haida roots. I have been learning, excuse me, I have been learning more about Bill Reed lately, thanks to my colleague Leon, and I encourage everyone else to do so as well. It's really beautiful and important art. I just entered Bill Reed BC into my search engine and found a whole lot of information about him, and I encourage you all to do the same if you have a chance. I already acknowledged that I'm on the traditional lands of the Tsleil-Waututh, Squamish, and Musqueam people, but I do want to encourage everyone else to reflect on the lands where they are. I know that we have attendees at this meeting from all over the land that we now call BC. And so I will encourage you to either privately reflect to yourself about the land that you're now on, or if you want to enter that in the chat, please feel free to do so as well, if that's helpful for anyone to recognize in the chat where they're coming to us from. With that then, can we please go to the next slide? And so we're just going to be talking briefly about some temporary COVID-related changes to welfare laws. And most of these have actually now either are about to expire or have expired, but we thought it would be useful to at least refer to them briefly in this presentation. Can we go to the next slide again, please? Thank you. Right, and so there is one major change that is still in effect, but may be coming to an end soon, as many of you probably already know, for family units that were receiving any kind of assistance from the Ministry of Social Development and Poverty Reduction, or who had a member with the Persons with Disabilities designation on April 2nd of 2020, certain COVID-related benefits are exempt as income and as an asset. That includes the Canada Recovery Benefit. It also included the CERB, the Canada Emergency Response Benefit, but of course that was folded, I think, into the Canada Recovery Benefit quite some time ago. Employment insurance is also exempt for those who were receiving assistance on April 2nd, 2020, as well as pandemic pay, which many of you probably heard about for some people working in essential services, they were given a top up of income for at least some period during the pandemic crisis. And this also was exempt as an asset and as income by the ministry. Right now, these exemptions are set to expire at the end of this year on December 31st, 2021. I think we know that there already has been a few previous extensions to that date. So right now, that's the deadline we're working with. It is certainly possible that the provincial government might decide to extend that deadline. So there's a chance that these COVID-related benefits will continue to be exempt, but we just don't know that for sure yet. Right now, you should assume that they're ending at the end of December 2021. If it looks like that's going to be extended again, most likely we'll put out some kind of update. It'll probably be mentioned on PovNet or elsewhere. Can we go to the next slide, please? Right, the other thing that has changed is we have reached the end of, so there was a law that allowed various government tribunals and agencies to extend deadlines for COVID-related reasons, and that law is no longer in effect. During the state of emergency related to the COVID-19 pandemic, the ministry's reconsideration branch and the Employment and Assistance Appeal Tribunal were allowed to waive or suspend deadlines if it was for reasons related to COVID-19. They did not have to do that, but they had the discretion to do it. However, near the end of September, that discretion ended because that was 90 days after the province ended the provincial state of emergency related to COVID. And so although there had been some leeway and some discretion for extending those deadlines for a long period of time during the pandemic, at this point that is over. And any deadlines for requesting a reconsideration of a ministry decision or appealing a reconsideration decision to the Employment and Assistance Appeal Tribunal must now be strictly adhered to. You should no longer, there's no longer a chance of getting a break on those deadlines.
Yeah, I'll just maybe weigh in on that a little bit. I think it's interesting to see, certainly on the Employment and Assistance Appeal Tribunal's website, it certainly still encourages clients to phone into the ministry if they have any issues with their timelines, if they think they might have missed a deadline. And Emily Drown is the chair of the tribunal. And I know that she was telling me that they found some cases where a client thought they might have missed a deadline, but actually hadn't because they were not clear or they misunderstood the day they actually received their decision from the ministry. And I also know that the tribunal is asking the minister to actually grant them a permanent discretion to extend timelines. So of course that hasn't happened and may never happen, but the tribunal found it useful certainly to have that ability and has asked for a permanent delegation of the ability to waive timelines. So we'll see what happens on that front.
And something else that Alice and I had talked about just in relation to the tribunal, and I don't think we need to get into it in too much detail, but we have found that there's been some changes to the tribunal process in terms of who are the members who are making decisions on behalf of the tribunal. I think we'll have a chance to talk about this more in later sessions, but I should say for now, my experience with the tribunal, with the Employment and Assistance Appeal Tribunal, is that they are pretty reasonable, and there is perhaps a higher chance of success there than there has been in past years. I guess you started talking about that, Allison, and I wanted to get into it a little more, but I don't want to dwell on that too much since I know we'll have another presentation coming up where we'll talk more about the tribunal, I think next week.
Yeah, there's definitely changes that have been happening at the tribunal, and it will be interesting to see how that continues to unfold. You know, it was just last year that the tribunal was given the ability to admit more evidence that hadn't been before the reconsideration officer. And I think we're seeing sort of how that plays out. And over time, you know, we may see that success rates start to increase. I think it's maybe a bit too early to say, but the tribunal is also always recruiting new members. They have difficulty filling positions in certain parts of the province. There were some new members appointed this year. And so if you know of people that you think would make good tribunal members, perhaps past coworkers or people you know in the community, take a look at the website and you'll see the recruitment information up there.
Thank you. Can we go to the next slide, please?
Okay, so we're starting to move into some of the non-temporary, we'll call them permanent changes in welfare law, although as you know, changes always happen in the legislation quite frequently, so nothing really is permanent when it comes to welfare. But before we launch into the details, I also wanted to bring folks' attention to the materials for the session. We have uploaded a copy of this gorgeous PowerPoint to SCED. And there is also a handout in SCED that you can find. So for those of you who have been at in-person conferences in the past, each year, I try to do quite a long, detailed handout, I'll call it a handout, that goes into much more detail about all of the changes that have happened to welfare law in the last year. That is available again this year and it's uploaded to SCED. You may want to print that out so that you can review it in more detail after the workshop, or pin it to your virtual bulletin board so you've got it as a ready reference. And I think that Sarah has just posted a link to it in the chat. So you should be able to find it there. So with that, I think I'll move into some of the substance of the more permanent changes. If we could have the next slide, please. So I think this was the biggest change of all to welfare this year was happily an increase to all welfare rates. There were two increases. So most of you were aware that there was an increase in May of this year. It was $175 for each adult recipient in a family unit, meaning there was no increase for dependent children. And that increase was followed by a slight adjustment of rates just very recently on October the 1st. Support rates were increased for most, but not all categories. I haven't heard much from the ministry on this. I think it's simply been termed kind of a minor adjustment to simplify the rates. And one thing you'll notice if you look at the rate charts now is that the numbers are rounder. Like we don't see any of that old, 42 cents or 56 cents at the end of rates. They're all now rounded up to the closest 50 cents or $1. But for some categories of benefits, the increases were a bit more significant. For some it was $2, $3. For other larger family units, it was more in the range of 10 or 15. So if you start seeing clients coming in with rates that you don't really recognize, because if you're like me, you've memorized some of the old rates that used to apply. If you're seeing numbers you don't recognize, just be aware that there have been those second changes this year. And take a look at the income assistance and disability rate assistance charts in the ministry policy manual to see, because those have been updated to include the October 1st increases. And I've got the rates for single people in each of the categories of benefits listed there, because those are actually very useful numbers to, I think, memorize so that you kind of know the benchmarks of the rates that you're looking for. For example, if you ask your client what kind of benefits they're receiving and they're not sure, but they say they're receiving $985 a month, you'll automatically know that that is PPMB benefits. So just to give some background to this increase, of course, even with these increases, people on welfare are living well below poverty lines. And the $175 increase is smaller than what was hoped for. We did, as you know, have temporary COVID crisis supplements of $300 a month early in the pandemic from April of last year until December. Then that dropped to, again, a temporary increase of $150 a month as a supplement from January to March. So that $175 permanent increase, somewhat between those two numbers, smaller than many people had advocated for, but still the largest increase in welfare rates in BC certainly that I can remember since the 90s and possibly before that as well. Can we have the next slide, please? So along with the welfare rate increase this year, we also had increases in the earnings exemptions for all categories of benefits. I should also add, should have gone with the last slide, I suppose, that there were also increases in, at the same time as the rates increased, there was an increase in the rate for senior supplement. Senior supplement hadn't increased since it was created in 1987, I think it was. So it has gone up for a single person by $50 a month. And that almost doubles it because it was used to be $49.30 a month. Now it's up to $99.30 for a single person, $220.50 a month for a couple. So earnings exemptions have also increased. That was January 1st. That was an expected change last year, and thankfully it did happen. So the annualized earnings exemption for people on PWD for single people is now up to $15,000 a month, up from $12,000 for couples. Where one adult in the family unit has the PWD designation, it's $18,000 a year. And where you have a family unit, a couple where both adults have the PWD designation, it's up to $30,000 a year. Next slide, please. We also had increases in the earnings exemptions for income assistance and benefits for people with multiple barriers were to employment. So for PPMB, the earnings exemption is up $200 to $900 a month.
Sorry, Allison.
Yeah, sorry, I just got accidentally muted there. So for singles and couples without children on income assistance, the earnings exemption is up to $500 a month from $400. So that of course includes probably the majority of folks, I would say, on income assistance. And then we have two other increases for certain families on income assistance. So if a family has a disabled dependent child or supported child that prevents them from leaving the home for employment for over 30 hours a week, the earnings exemption is now $900 a month. And for other families with dependent children on income assistance, it's up to $750 a month.
I just wanted to step back and I'm sure most people are aware of this, but just to talk about what we mean by the earnings exemption, this is the amount that a person who is receiving a certain type of benefit is allowed to receive from employment or from self-employment or other forms of work without it affecting the benefits they receive from the ministry. So for example, if you're on PWD and you have that $15,000 annualized earning exemption, that means during a calendar year, you can go out and work and earn up to $15,000 before it affects the amount of PWD or disability assistance benefits you receive. If you go over that $15,000 on PWD, then for your employment income, that is, then you're going to start getting your benefits clawed back in the same amount as the income you receive over $15,000. And I think probably everyone knows that, but I just thought it would be helpful to make sure it's clear.
Well, definitely. I think we're ready for the next slide. And Andrew, this one is yours.
Yeah. So another change that has been made this year is that starting in April 2021, many of you probably know that ICBC started issuing refunds to most customers. And this, I understand there was two bases for those refunds. One was a COVID-related rebate that I gather applied to everyone who paid ICBC premium, since it seems like ICBC's fees went down for a period of, or ICBC's expenses rather, went down for a period of time during the pandemic. And then in addition to that, there have been some fairly high-profile changes to ICBC rules, which the government says, or which ICBC says, are going to reduce premium or have reduced premiums for everyone, are going to reduce the cost of the system. And so as a result of that, many people who had already paid their ICBC premiums or had already started paying them for the year started receiving refunds. I personally got a check from ICBC, which came as a surprise to me, but it was nice to have, I suppose. And any refunds or rebates from ICBC are exempted as income as an asset for anyone who receives any kind of benefits from the ministry, whether it's income assistance, hardship assistance, PPMB, or disability assistance for those with the PWD rationale. And as Allison and I were discussing a little while ago before we started this presentation, the rationale here appears to be that this is money. This is money that has already been spent in the sense that by the time you had received these refund, by the time you received the refund, you had already paid the money and it was being sent back to you. And so it seems like what the ministry is doing here is making sure that it doesn't get held against you twice in terms of your benefit amount. Since you've already paid it, they're not going to take away from your benefits when you get that money back. And I understand that there's been some similar programs in the past where the government has created refunds for example, fuel or other necessary expenses, and that the ministry has allowed people to keep those refunds or those rebates without it affecting the ongoing benefits that they receive. Thank you. Yes, going to the next slide. We also want to talk about work experience opportunities grants, which is another new or at least more formalized exemption from the ministry. The Work Experience Opportunities Grant Program was created to give marginalized people opportunities to increase their ability to participate in the labor market. And so as of January 1st of this year, any income, goods, or services that someone received from participating in the Work Experience Opportunities Grant Program was exempt as both income as an asset for anyone on any category of benefit, whether it's income assistance, hardship assistance, PPMB, or disability assistance. The most recent grants were given in March of 2021 to nonprofits and social enterprises and charities and businesses so that they could provide 12 weeks of work experience placements to people who were deemed to be qualified for that program. And so for those individuals who received income through this program, that income is not going to be or should not be clawed back or deducted from their future benefits by whether they're on any kind of any category of benefits.
Mm-hmm. And I think it remains to be seen if there will be further grants. As Andrew said, these are really designed to sort of facilitate recovery from the economic effects of COVID. And so I think that we're certainly not over that yet. So I think that we may be seeing some more money being placed into these grants. And so even as agencies that you work with, would be in a position to apply for some of them. So it may be something that your clients may be able to access down the road. And I think we're ready for the next slide. Okay, so this change is a change that affects only income assistance and students. There aren't any changes to the rules for students who are receiving disability assistance. But this change happened in July, and I think it's fairly interesting. So with this change, all recipients of income assistance are potentially eligible, so may ask the ministry for pre-approval to attend full-time studies for what the ministry calls a funded program of studies. So a funded program of studies means an educational program that you can apply for student loans for. And that exemption, if you're pre-approved to attend full-time studies for a program that student loans are available for, you can be approved for a period of up to 2 years. It's quite a big change because prior to this, only single parents were able to apply for pre-approval to attend full-time studies on this basis. And single parents could only be pre-approved for a program for a total of up to 1 year. So now we have all recipients in the same position single parents were previously. There are other conditions of eligibility that apply. So in order to be pre-approved, two things have to be true. First, your employment plan has to include a condition that requires you to attend this program of studies. So the person would work with the worker preparing their employment plan, talk about their interests, maybe try and identify a specific program they're interested in attending and see if it can be included in their employment plan. And second, the person has to have been on assistance for the last 3 months. That's consecutive. Although that rule has some leeway, it can be waived by the ministry if there are exceptional circumstances. So let's move on to the next slide, please. So at the same time that the category of people who can apply to the ministry for pre-approval to be in full-time studies that they can get student loans for, same time that was expanded, there's also an expansion in the types of expenses that can be exempted from non-student loan funding. So if somebody goes back to school, there's different types of financial assistance that can be available, including grants, bursaries, scholarships, training allowances. They've also included withdrawals from an RESP, a Registered Education Savings Program here. So if somebody does receive those sorts of funding related to them going back to school, and they've been pre-approved by the ministry to go back to school full-time in a program that's eligible for student loans, then from these other sources of money, they can ask the ministry to exempt those other sources of money up to the total of their daycare costs, education costs, and here's what's new, education-related living costs. That's important because that's quite a big category. It includes the cost of food, shelter, clothing, utilities, and any other expenses the ministry agrees the person needs to participate in the educational program. So obviously that's a big chunk of money. So I think what it means that no matter if someone is pre-approved to go back to school and they receive scholarships, grants, etc., probably all of these costs added up together will be at least as high as the other monies they're receiving. So I think it means that they're probably eligible to have all of those other monies that are intended to help with them with school exempted by the ministry. And so if that were to happen, then they could continue to receive income assistance during the time that they're back in school full time. So there's not a lot of detail about this yet. I took this information simply from the Order in Council that announced the change back in July. I haven't heard the ministry discuss this change in any of the consultation meetings we've been in. And I looked at the ministry policy manual, and on this topic has not been updated yet either. So I suspect that the ministry is just laying the groundwork for some changes, some further changes that they may be announcing in the future. I'm not sure. Maybe there's someone in the audience who's heard more about it than me. And if you have, then feel free to drop it in the chat. But it's an interesting change and it is in effect now. So if you have clients on income assistance who are interested in going back to school full time for post-secondary studies that student loans can be available for, then this may be of interest to them.
And Alison, I'll just mention there's a couple of questions come up in the chat that I think we can address pretty briefly. One is whether this change applies for people on PWD, and my understanding is that it does not, at least at this stage. This is just for people who are receiving income assistance.
It does not. However, I will say that the existing rules about students and disability assistance are more generous already than these rules that apply to folks on income assistance. Basically, you have to remember with income assistance that most people on income assistance do have employment-related obligations. You have to look for work and so on. And in principle, if you're in school full-time, you can't do that. So which is why you need, if you're on income assistance, you need the ministry's pre-approval to go back to school full-time in this situation. The rules for students in disability assistance are quite different because people on disability assistance don't have employment-related obligations. There's a pretty good summary of the rules that apply to students on disability assistance in the ministry policy manual. So if you want to refresh yourself on those, I'd suggest you take a look there. And then the next question I see is on this topic, how does the ministry define exceptional circumstances? Yeah, good question. This change only happened in July. And so that references to the fact that, so in general, somebody has to have been on assistance for 3 consecutive months before they can ask the ministry for pre-approval to go back to school under this topic. But that 3 months can be waived in exceptional circumstances. So I haven't seen any cases yet. It's only since July, and of course this semester only started in September. So I think it remains to be seen what exceptional circumstances look like. It may be people that maybe you were in a undergrad program and had a crisis in your life after 2 years and spent a year back on income. Well, I guess if you're on income assistance, you would have met for a year, you would have met those 3 months. I think the short answer is I don't know. It remains to be seen. Okay. All right. So this is a section of the presentation that I'm actually the most excited about. I think this is the most significant change in the last year. And many of you will know that there was in September, there was a great broadening of the types of compensation for loss of housing. So those of you who do tenancy advocacy will know that when people lose their housing, when they're formally evicted, or when they reach a deal with their landlord to move out, or when they receive money under municipal tenant relocation programs, or for a variety of other reasons, there's lots of different sources of funding that they can receive for losing their housing. And prior to this change that took place in September, the ministry rules about what was and wasn't exempt for eviction compensation were quite strict, and they were unevenly applied. So in the past, eviction compensation could only be exempted as an other award that was exempt up to the person's asset exemption level. And oftentimes the ministry would ask for documents to prove, oh, is this money really for eviction? Let me see your eviction notice. Let me see your decision from the RTB saying that you're entitled to this money, or so on and so forth. And of course, in many cases, clients don't have paperwork. They may have moved out willingly, voluntarily, without receiving an eviction notice, simply exactly because the landlord offered to pay them quite a bit of money to move out. And so these changes really capture, I think, most situations where tenants or licensees or people in other residential living arrangements receive money due to the loss of the residential use of housing. So these slides summarize the changes. The ministry uses the term tenant compensation to refer to this new exemption. And if you're looking for ministry policy about this new change, you'll find that there's a new topic in the ministry policy manual under the income and exemptions category. There's now an entry for tenant compensation. And the next slide details some of the particulars of the changes. So the regulation exempts tenant compensation as unearned income and as an asset for all categories of benefits. The criteria are that the person, well, first of all, I'll say the criteria are so broad that they're not, usually we're trying to fit things into very narrow criteria. Here, the criteria are so broad that I think you can argue virtually any money somebody receives due to the loss of the residential use of their housing is in fact tenant compensation that should be exempted. So first, the person can be a tenant under the Residential Tenancy Act or the Manufactured Home Park Tenancy Act, but they don't have to be. They can also be a licensee, They can be simply an occupant, such as a roommate or a lessee. In fact, this money will be exempt if they had a similar right or permission to use the premises for residential purposes, which of course is very broad. So the money will be exempt if it's paid for full or partial compensation for the loss of the residential use of premises, which includes for eviction, relocation, demolition, and I think this one's very interesting, temporary displacement during repair, renovation, or redevelopment, or as an inducement to cease or suspend residential use. So it can be a voluntary payment from the landlord just to persuade the person to move out. It can be money received for temporary displacement. It doesn't have to be permanent loss of the residential use of the premises. It can be temporary. Somebody moves out to facilitate renovations, for example, and the landlord gives them some compensation for that, then that could be exempt by the ministry. Again, another very general criteria, the money. So the money, first of all, has to be paid by the person responsible for the residential premises in some way. So the landlord, the owner, the manager, or a person in a similar position. But the money can be paid for any reason, pretty much. It's paid under a contract, it can be paid under policy or a law, or paid voluntarily at the discretion of the person responsible for the residential premises. And it doesn't matter if it's a one-time payment or a series of payments. A series of payments is equally exempt as a one-time payment if it's tenant compensation. This has been a problem in the past because previously money was tended to be exempted only by the ministry only if it was paid in one lump sum. But here the legislation specifically acknowledges that, if the landlord pays you $1,000 as compensation and they pay it to you in 10 months of installments of $100 a month, all of those payments should be exempt as tenant compensation. So these rules are quite new, and I think that it remains to be seen exactly how they'll play out. One thing to note is that tenant compensation that comes from sources other than the landlord type person, let's say the landlord has insurance and maybe there's a flood, and the client temporarily uses the residential use of their premises because of the flood, and the insurance company pays them money for that. That money does not fall within tenant compensation because the regulation is clear that the money has to come from the person responsible for the residential premises, not from a third party like an insurance company. So just going to take a look at the chat and see if there's questions there right now.
Doesn't look like any more questions now.
No.
And so I will say that I think that is all of the permanent changes to welfare rules that we had planned to cover in our presentation. It is not all of the permanent changes to welfare rules. If you look at the handout that Allison prepared, there is a number of additional changes that have been made. We just wanted to highlight some of what we thought were the ones that were either most important or the ones that would be most likely to come up in the advocates' work. So we do encourage you to take a look at the handout and make sure you're familiar with all of the other changes. But what we've tried to do is cover the ones that you're more likely to see in your work. We have a couple of fact patterns to go through. And so can we please go to the next slide? Thank you. Some great transitions in these slides. And so Allison, I think if it's okay with you, I'm just going to read through scenario 1 and we'll see what kind of response we get. And I think we had not planned to go into breakout groups just because we don't have a great deal of time here. I don't know if we'll have a chance to have much of a discussion given the limited time and the fairly big group that we have here. But I'm just going to read through this first scenario anyway, and I will encourage anyone who has thoughts on it. We have some questions on the next slide coming. If anyone has thoughts on those to include your answer in the chat, and then perhaps we can have a little bit of a discussion about that, time permitting. Does that make sense, Allison?
Sure, I think that makes sense.
So in this first scenario, I have named our tenant Leon in homage to my colleague who created this presentation. And Leon, in this scenario, this fictitious Leon, receives income assistance, and he rents a basement suite from his landlord, Jamie. And in October, Jamie told Leon about Jamie's elderly father, who lives on his own, but needed more and more support from Jamie. And so Jamie said to Leon she was considering asking her father to move into the basement suite where Leon now lives. Jamie did not give Leon an eviction notice. She was just talking about it, but Leon was thinking about moving out anyway. So he told Jamie that he would move out by the end of the month if she gave him $500 to help cover his moving costs. Jamie agreed to this arrangement, and Leon went ahead and moved out before the end of October. And it doesn't say it here, but let's say he did get that $500 from Jamie in October. And then in December, Jamie sent Leon a Christmas card, and it said, "Thanks for being a good tenant," and it included a check for an additional $500. So this is the fact scenario we're looking at. Can we please go to the next slide? And so Leon now has come to you in your office, and they have a couple of questions. First of all, do I have to report those payments from Jamie to the ministry? And I'm getting a message that my internet connection is unstable, so I hope I don't get frozen here. Right, the question was, do I have to report the payments from Jamie to the ministry? And what will the ministry do if I report it? And what can I do? What can Leon do if the ministry reduces his IA benefits, his income assistance benefits, because of the payments received from Jamie?
Okay, so let's have it in the chat. So first question is, does Leon have to report the payments from Jamie to the ministry? Oh, Michelle is first to the buzzer. Yes, to report, money should be exempt. Who else wants to weigh in? Yes, okay. Yes, they must report. It's income that may affect their eligibility for income assistance. And so Leon has a duty to report the money to the ministry. Andrew, do you want to tackle what will the ministry do?
I see that there was one comment saying that the ministry should exempt all this money. Anyone else have any thoughts about this? And just to be clear, what that means is if the money is exempted, it should not affect Leon's first benefits. It should not affect Leon's ongoing benefits. It shouldn't be deducted from later payments.
Mm-hmm. And we don't have the fact pattern up still. Also, just remind folks, we had the $500 that Jamie paid Leon for his moving costs. And then we have the Christmas card a few months later with $500 in it saying, "Thanks for being a good tenant." Is that right?
That's our fact scenario. And so I think there's been a couple of answers that, and I see there's a couple more coming in now. And the consensus seems to be that it should be exempt. And I think I agree with that. Based on what we're seeing of the new rules here, I think there is at least a case to be made for both these payments to be exempted. Now, I will say the second payment, the $500 with the Christmas card, "Thanks for being a good tenant," that I would, my view is that might be a little more arguable. I am not as confident the ministry would exempt that. I should say you could call that a gift. In some scenario, I think Leon was on income assistance, and I can't recall off the top of my head if the rules for gifts on income assistance are different from on PWD, where a gift would be exempted.
They are different. So for disability assistance, recurring gifts or repeated gifts can be exempted. For income assistance, only one-time gifts can be exempted. And under both schemes, they're exempt up to the person's asset exemption level. They're exempt as income up to the asset exemption level. So I think I agree with you that you could, certainly the money for moving costs, I think you could try to have exempted as tenant compensation. The $500 in the Christmas card after he's already moved out, probably harder to have exempted as tenant compensation, but might be worth trying. And if it didn't succeed as being exempted for tenant compensation, I think plan B would be, yeah, Jamie sent me a Christmas gift. Gifts are exempt up to my asset exemption level as income. It should be exempt as income up to my asset exemption level.
And so the last question, as sort of a practical matter, is what if the ministry disagrees with what we're saying here? And what if they decide to claw back Jamie's benefits? What if they reduce, Leon's income assistance benefits because of the payments from Jamie? As a practical matter, what can Leon do about that? And the answers coming in now, I think, are right on the money. There's people are saying that Leon should request the ministry, should ask the ministry to reconsider its decision, should submit a request for reconsideration. And I agree with that. I think that's the best move here. And then see what happens with the reconsideration decision. And maybe if you're still not successful, this is a case to consider going to the Employment and Assistance Appeal Tribunal. Maybe we don't have enough information right now to make that decision, but as a first step, I think there's nothing to lose by doing that request for reconsideration.
Okay, we have a couple more fact patterns and we have a little bit of time. So any more questions about the first fact pattern or moving on to the second? I've got the slide up, but still, if you have questions about the first fact pattern, can you drop them in the chat now, or feel free to unmute yourself and ask it verbally.
Well, I'll go ahead and read out this scenario because it's a fictitious version of myself. In this scenario, Andrew uses they, them pronouns, which I do not, but I wanted to make this somewhat more inclusive. Andrew lives on their own and receives CPP disability benefits in the amount of $1,200 per month as their only source of income. 2 years ago, Andrew applied for PWD benefits. Let's say they contacted the ministry, but they were told they were ineligible due to their CPP-D benefits. And in this scenario, I know, well, just for simplicity's sake, let's say that Andrew has been receiving $1,200 per month all along for the last couple of years. I think in real life, the amount would fluctuate a little bit, but it makes it a little simpler for us to say $100 all along. And now Andrew comes to you and says they need dental treatment and a new pair of glasses, but they have no insurance and no savings. What can we do to help Andrew? What might be different from a couple of years ago? Yeah, so the answers we're seeing in the chat now suggest that Andrew probably would now be approved for the PWD benefit, even though they were not eligible 2 years ago. That was when, of course, the PWD benefit was lower than $1,200 a year. And as we know, if you're receiving an amount, if you're receiving CPP disability benefits and it exceeds the amount that you're likely to get from disability assistance, then you're probably not going to get disability assistance. But things have changed. And now, even if Andrew is receiving $1,200 per month in CPP disability benefits, they are still going to be eligible for PWD, and they're only going to get a small amount from PWD. It's only going to be, $150 and change per month in addition to their CPP-D benefits. But I think, as everyone is identifying, that also opens the door to all the possible health supplements that in some cases come along with the PWD designation. And so Andrew will, or at least might be eligible to get the dental treatment and the new pair of glasses that they need.
Yeah. Folks in the chat are also pointing out that because he's already got CPP disability, or they've already got CPP disability, they can use the simplified prescribed class application for their PWD designation, which will make it much easier than if they had to do the full PWD application form. Let's just see what's coming in here. could they be eligible for a retroactive PWD top-up payment? That's an interesting question. I would say generally no. There's rules in the regulations about the effective date of an application for PWD designation. It's generally the month after the PWD designation is granted. Some different rules apply here and there, but I think a retroactive argument would only come up if there had been some mistake, by the ministry. If maybe the client had talked to a worker 6 months ago and the worker made a mistake. I can't do the math at the moment off the top of my head, but if a worker had told the client, well, don't bother applying now, you can't apply now, your income's too high, and that was in fact incorrect, then maybe there's some argument that because the client relied on the ministry's advice, that there could be retroactive payments in that sort of situation, but the fact pattern doesn't raise that here.
We've got one more fact pattern, but I see that we just have a couple minutes left before 10. And I know that some people here, I think including Allison, are going to have to go shortly because there is another session at 10. So what I will suggest is I can stick around for a few minutes. Allison, I know you're not able to stay, but I can stick around and go through. We just have one more brief fact scenario about tenant compensation. And so if it's okay with you, Allison, I will get into that. And if you have to go at some point, that would be fine, of course.
Yeah, I have to leave right at 10, but we've got 3 minutes. I'll stick around for that and see where we get.
And just to be clear, the next session is at 10:15, not 10, for the participants.
Thanks, Melissa.
Okay, so for this last scenario then, I'm just going to read through it. Patricia this is another tenant compensation situation. Patricia is on disability assistance. She has been a tenant for 10 years in a house that her landlord has received permission to demolish. She lives in a city that has a tenant relocation and protection policy, and she received 5 months rent, which for her was $3,500 from her landlord under the TRPP, the tenant relocation and protection policy, and she received $700 more under the Residential Tenancy Act because she had to move out so that her landlord could demolish the house. And so Patricia has come to you and she wants to know if the $4,200, the total amount that she received, will affect her disability assistance. She also has a question about her moving costs. She's planning to move next month and she wants the ministry to pay for her moving costs. And the question is, what do you tell her? And I think, Allison, this alludes to a provision of the ministry's policy that we did not end up highlighting in our presentation, but we can discuss it a little bit now. So first question, is that all that payment she received, the $3,500 under the TRPP and $700 under the RTA, will that affect Patricia's disability assistance in light of the new rules about tenant compensation? Does anyone have any thoughts about that?
Okay, so Andre's saying should be exempt. Michelle's asking, is not in a location that has a TRPP. So that's not something they're familiar with. So under a tenant relocation and protection policy, it's a city bylaw that requires a landlord to pay additional money additional to what's required by the RTA. So the money under a TRPP comes from the landlord, doesn't come from a third party.
So I think the consensus that is emerging in the chat is that it should all be exempt and therefore it should not affect Patricia's disability assistance. And I believe that's correct. As we heard, some of the rules about the new tenant compensation policy provide that if the money is paid under a contract, policy, or enactment, or even voluntarily, even if the landlord wasn't forced to pay it and just chose to anyway, then the money will be exempt. And so in this case, since it's being paid from the landlord as a result of the city's tenant relocation protection policy, I believe it would fall under the exemption that's been created. And I think it is likely that it would not affect Patricia's disability assistance. There's some questions coming in now about moving as well, or excuse me, we already asked the question. There's some answers coming in about moving now. Patricia wants the ministry to pay for her moving costs, which before this tenant compensation program, or before these new rules about tenant compensation, there was a procedure, a process to go through where Patricia could ask the ministry to pre-approve her moving costs. The question here is, does this new rule, does the tenant compensation policy, is this going to affect whether the ministry is going to pay Patricia's moving costs?
Mm-hmm. So Natasha is saying moving costs could be covered if she's moving to a cheaper place. That's true. So there's certain criteria that still have to be met to get moving costs from the ministry. And there's only certain reasons for moving that could be considered. So one is, like Natasha says, moving to a cheaper place. Having your place demolished is also a reason that the ministry can agree to pay your moving costs. Payment of moving costs is always discretionary. You have to apply for pre-approval, except in exceptional circumstances. You have to have a reason for moving that's kind of covered by the ministry. And the last criteria is there are no additional resources available to the family unit. So I think what the fact pattern sort of gets at is, oh, well, is this $4,200 an additional resource that the ministry is going to think she has to access to pay for her moving costs, or can you argue that it's not?
I see in the chat that Simon has found the ministry policy providing that tenant compensation for moving costs are not to be considered resources when determining eligibility for the moving transportation and living cost supplement. So I'm not sure that's necessarily clear from the change in the law, but it appears that the ministry has changed its own policy so that Patricia in this situation would not be required, or well, shouldn't say she would not be required, but would not have to, not necessarily have to use the money received from the TRPP and that she received through the RTA in order to cover moving costs. They could still make the claim that they have no other resources available to pay those costs.
Mm-hmm. I think like the policy is very helpful, but it's still not that clear. So it's that compensation for tenant compensation for moving costs are not to be considered resources in this situation. So it would have been nice if they just said tenant compensation isn't to be considered a resource, but it's tenant compensation for moving costs. So that begs the question, is the whole of that $4,200 for moving costs? Is only the RTA money for moving costs? Who's to say? There's some ambiguity in the policy, which still leaves the room, I think, to make arguments that the whole thing should be exempted, but a bit of a gray area. And with that, I'm going to leave this in your capable hands, Andrew, because I have to duck out to get ready for the next workshop. But thanks everybody for attending.
So I will stick around. The only thing further I'll have to say about that is, just like before with the other scenario, I will say as a practical matter, probably, I mean, if the ministry does not not pay her moving costs, as a practical matter, I think you got nothing to lose by requesting reconsideration of that. As Allison said, we don't really know yet how that's going to play out. I think the only way to find out is just to, make the request and see what the ministry does. And perhaps sooner or later, the issue might go to the Employment and Assistance Appeal Tribunal. But until then, all we can do is hope for the best and request reconsideration if necessary. Can we go to the next slide, please? Right, yeah, so that brings us to the end of our presentation. To thank my colleague Leon for designing these beautiful slides. I remember seeing this one myself in the Museum of Anthropology at UBC. This is, I think, Raven discovering the first men in this slide. If there are any questions, like I said, I can stick around for a few more minutes, and I'd be happy to try to answer questions in the chat, or if anyone wants to speak up. And if we can just go to the last slide, it has contact information for both myself and Allison. And so I do, and I know I speak for Allison on this as well. We definitely encourage you to contact us if you have questions about the changes we've discussed today or about anything else. I know that Allison and I know myself as well are always very happy to talk about welfare rules. Please feel free to contact me by email. And I will do my best to get back to you as soon as I can. I know Allison will do the same. That's all I had to say, but I'll stick around for a few minutes. If anyone has any questions, I'm here, or if you think of questions later, please feel free to send me an email.